right, we are now on the record for Wednesday morning civil docket for September 15, 2021, and I'll take quick announcements. Attorney Bobby Garcia.
Yes, ma'am. I've got to number 25 on the docket. I see that Rory Golivera is on, and we've got our case already set up for mediation in November, Your Honor, and it's just a status hearing.
Okay, anything to add from defense counsel?
No, Your Honor.
Okay, so then when in November are you all mediating?
Your Honor, I will tell you that the exact time here. It's November, I believe, the 18th.
Okay, let's come back on December the 1st and let me know how that went.
December the 1st?
At 9:30.
9:30, Your Honor, we shall. And I've just got one other matter that'll take 30 seconds.
Okay.
And it's number 13 on the docket, Your Honor. It's a motion for substituted service. And all we're asking is that we go and we pin this thing up on the front door of this individual.
Okay. Is the affidavit on file?
Yes, ma'am, it sure is with the process server. It's on file, and we've also got the order and everything. Okay.
All right. It said I'm having trouble with my Odyssey this morning, so I don't have access to that. But as long as the affidavit is on file and has the required information from the statute, I'll go ahead and grant that substitution.
Yes, ma'am. That's all.
And you said there is an order also, right?
Yes, ma'am, there is.
Okay. I'll ask for that to be forwarded to my queue. Okay. Anything else, sir?
No, ma'am. That's all. And I appreciate your, everything you do, Your Honor. Thank you so much.
Thank you. Mr. Oliveira, did you have another case?
Yes, I had another one with, I think Marisa Hernandez is on the other side, right? Marisa Carranza. It's cause number 1301.
Okay. Do you know what number that is on the court's docket by chance?
No, I don't.
Okay, I got it. Number 20. All right, CL 141300-I, Alicia Alonso versus FEMA Enterprises. Okay, and is Ms. Hernandez present?
I don't see her, Your Honor.
You're making the announcement for both of you?
Yeah, this one was on the drop docket and got reinstated, and I think we're setting it up for mediation. We're trying to set it up for mediation in the next 30 days.
Okay. I'll give you some time to see what you're going to do. I'll have you come back also on December the 1st at 9:30.
Okay, thank you, Your Honor.
Okay, anything else, sir?
No, Your Honor, may be excused.
You certainly may.
Thank you. Have a good day.
Likewise, Attorney Nereida Lopez Singletary. Ms. Lopez Singletary. Okay. Attorney Marco de Luna.
Good morning, Judge.
Good morning, sir.
Judge, I have number 30 on the docket.
F002521-9 in the matter of the marriage of Norma Trevino and Ernesto Trevino. Is Mr. Davis present?
Judge, I was hoping he'd be on by now. I talked to him yesterday. It said for a status judge with a possible approval, but I can let the court know that we're not ready for approval. We haven't received even it's going to be, I believe it's going to be an agreement by the party, Judge.
Okay.
The problem is that we haven't received any
Proposal?
any final decree on it, Judge. Agreed final divorce decree to be able to sign and to prove up today.
Okay. And
I talked to him yesterday, and I talked to my client, and my client said he was going to talk to his wife, future ex-wife, and there's, like I said, they're still selling some property and stuff like that, Judge. So we wouldn't be ready to finalize it today.
Okay, so how much time do y'all need in order to review the terms?
Maybe we could have maybe like 2 weeks, Judge. At least 2 weeks, Judge, so I can at least get that in there, get my client in to go look it over. But like I said, pretty sure that it's going to be an agreed divorce decree.
Okay. I don't have, in October, the earliest setting I have is October 27th. If you do have it before then, just notify us and we'll squeeze you in somewhere.
Okay, I'll let you know, Judge. I'll talk to Mr. Davis right now. I'll send him a text.
Okay, so I'll just switch you to October 27th at 9:30.
Can
And
I-
if everything gets taken care of before then, let me know.
Can I say something?
Oh, Ms. Trevino,
Yes, I'm here, and we've been ready for a long time. It's Mr. De Luna that keeps prolonging this. I want a divorce already. I've been waiting and waiting, and they keep saying another month, another month. I am in a very stressful relationship right now. We live in the same home. I can't do this anymore. He does not leave the home, and I have nowhere to go.
Miss, well,
this
the
is a
thing
quarter-
is that you need your attorney present. Perhaps there's something that needs to be communicated to you.
Well,
I wouldn't be
no way-
able to accept, hold on. I would not be able to accept a prove up on your behalf unless I have something such as either the decree or that the terms have already been agreed to.
Well, I do have a decree, and I forwarded to Ernesto, and he has it.
Okay, ma'am, but his attorney's saying that he hasn't reviewed a decree.
Because they
So,
don't talk to each other. Ernesto and Mr. De Luna, they don't even talk to each other.
okay, ma'am. All right. I'm gonna be taking the attorney's announcement. I'm taking him at his word. So I'm going to give you all an opportunity to discuss it. I would suggest you get in touch with Mr. Davis. Mr. De Luna is going to get in touch with Mr. Davis as well. So I am good, even though I'm giving you October 27th, I'm allowing you to come in sooner than that if everything is signed off before then. So it doesn't mean it'll be October 27th. It could very well be a lot sooner. But until I know that all of y'all are on the same page, which means that you're either signing off on a decree or there's an agreement that you all are going to be proving up onto the record, then we'll go ahead and move forward. So I'm going to give you that date. Go ahead and contact Mr. Davis. I'll give Mr. De Luna an opportunity to do the same. Okay?
Okay.
And I understand. I understand. Yes, sir.
Judge, I'll actually text Mr. Davis. I'm not going to get into it with Mr. Trevino, Judge. Like I said, I thought this was, I mean, everything's been amicable. I mean, they literally, I mean, I got on the case late because it was going to be agreed to. This about what she's talking about, I have no idea, Judge, but I'll talk to Mr. Davis, and if the court wants me back on, I'll talk to Mr. Davis and we can log back on as soon as he gets on or he lets me know. I don't want the court to think that I'm doing anything dishonest in this case.
No, well, Mr. Davis is just logging in.
Okay, perfect.
Okay, let me just.
I apologize, Judge.
That's fine. Mr. Davis, can you hear me?
Yes, ma'am, I can hear you.
Okay, I just called your case on F0025-21-9. I do have Mr. De Luna on, and your client is also on.
Yes, ma'am. Perfect. Tim Davis here for the petitioner.
Okay, so it's my understanding, are you all still reviewing the terms of this agreement?
Judge, my client wants to go forward and get divorced, but that's the issue. I don't think Marco's been able to communicate with his client as of yesterday to make sure we have an agreement, but the parties say they have an agreement.
Judge, I've been in contact with my client. I speak to him at least 2 times a week. The problem that they're not understanding is that you can't have the proposed agreement that was first sent out is talking about that's abstract numbers. That's in I'm going to get 50% of what the retirement is. They haven't even done a quadro. He has Mr. Trevino is a works for D. Wilson Construction is in a higher income, and it's, I mean, you don't do a quadro, you don't just go out to a final degree and say, okay, we're going to get 50% of what the retirement is. What does that mean at this point? A
Sure you
quadro
can.
hasn't even been done. That stuff hasn't been done. That's not me. I literally just got on the case on the last hearing. So to blame me for not.
No,
having-
I'm not blaming him. I'm just saying it's kind of, I'm kind of having the same issues on my side as well.
And that's so the court is hearing. It has nothing to do with me. I'm trying to fix something that was thrown out there, a decree, so we don't come back 5 years from now, and they're asking, what does 50% of whatever mean when it started or when it, I'm trying to fix this is what I'm trying to do, Judge.
Okay, so Mr. Davis, what I said is I'm going to give you all an opportunity to review those terms and come to a final agreement, and I'm going to reset you for October 27th at 9:30. If by chance you all do have a signed decree before then, contact my office and I'll squeeze you in on a docket so that you can do a prove up.
Yes, ma'am.
Okay, so you'll need to explain that to your client because she did make some comments earlier. So that way she understands why it's necessary to have that agreement prior to doing a prove up hearing. Okay,
Will, Judge.
so anything else on this?
Not on this case.
No, Your Honor,
Okay.
that's all I have, Judge. May I be excused?
Yes, you may, sir. Okay,
Thank you.
Mr. Davis, did you have another case?
Yes, Judge, I'm here on number 35. with
Okay,
Judge Paul.
Ms. Trevino is excused as well. Okay, F 4121-19-9 in the matter of the marriage of Gabriela Flores and Ramon Flores. I have attorney Jonathan Ball on the other side.
Present, Your Honor.
Okay, and what is the announcement, Counselor?
Judge, we had filed, I guess, for a status hearing, maybe for the court to rule on the hearing we were at previously. This involved a case where my client is a wounded veteran, and the issue was whether the home that was provided to them through one of the wounded veteran charities was his separate property or whether it was community property based upon the deeds and the records and everything that was signed off on. The court had mentioned that Your Honor was going to call and speak to some folks in that organization in order to facilitate a ruling. And my client had asked me to please contact the court and see if there was a ruling or if the court needed any further information. That's where we're at.
Okay, yes, I did, as a matter of fact. And now that you brought it back to my attention, I realized that they didn't send me the information that I had requested.
Okay.
But now that it's back on my radar, I will follow up on that myself because I had requested certain information. They had told me the person that was in charge of that in that the number that you gave me was going to get back with me with that information. And now that I see you back on, I realize they never sent it to me. So I do need to follow up with that.
Understand.
Okay, Mr. Davis, did you want to add anything?
No, Judge, that's exactly correct. We've already briefed and argued everything, and that was my recollection as well. You were going to speak to the director of that organization.
Okay, let's come back on October 27th at 9:30, and one way or another, I'll have a ruling on that.
Very well.
Yes, ma'am, Judge. Thank you.
Thank you,
Okay.
Judge.
All
Appreciate
right,
it, Judge.
anything else, gentlemen?
No, ma'am.
Not for me, Judge. Thank you. May I be excused?
Yes.
Thank you,
Thank you.
Judge.
Okay. Attorney Nereida Lopez Singletary. Okay, Attorney Jesse Contreras.
Your Honor, good morning.
Good morning, sir.
Your Honor, I'm here on a case with Ms. Singletary. It's a
Okay.
status here. It's a status hearing this morning, Your Honor, but I'll wait for her to log in.
Well,
If you don't
she's
mind.
logged in, but I'm assuming she's in another court.
Gotcha.
Because she's not responding.
Can you recall the case, Your Honor? It's just, again, it's a status hearing this morning.
I will.
On the family case.
Okay.
All right, thank you so much, Your Honor.
Uh-huh. Attorney Leslie Sun.
Good morning, Judge. I have number 12 on your docket.
Okay. That's
And it is a-
CL 21-2175-I Discover Bank versus Fernando Alvarado. Okay.
Yes, Judge, this is a hearing on plaintiff's motion for substitute service that was filed on July 22nd. It contains an affidavit from plaintiff's process server with the attempts that were made along with the LexisNexis accurate for collections verification that defendant does reside at that address.
Okay. Then provided that everything is on there that's statutorily required, I'll grant that motion. Right now, like I said, I'm having issues accessing that.
Okay.
But is there an order on file?
Yes, Judge.
Okay. All right, anything else?
No, Judge. Thank you very much.
Okay, you're welcome. Have a good day.
You too.
Attorney Danielle Rodriguez.
Good morning, Judge. I'm here on number 28.
Okay. CL 210501-I Ramiro Gonzalez et al. Versus Jose Guerra.
Danielle Rodriguez for the plaintiffs, and I believe defense counsel's also logged on.
Yes, Nick Denzer for defendant Guerra.
And Hannah Hubert for defendant Rosales.
Okay. And what is the announcement?
Your Honor, we're set for a status hearing. Since the last status hearing, a new defendant has been brought in. That's the defendant Cesar Rosales. So right now we're in the process of doing written discovery with that defendant.
Okay. Anything to add from the defense?
No, Your Honor.
No, Judge.
Okay. So then how much time would you need in order to give me a good status on this?
Let's say another 45 days or so.
Okay. So then after you complete your discovery with Mr. Rosales, are you going to continue with depositions or are y'all jumping into mediation?
I believe the defense would probably want to take depositions. And then after the depositions, we can go to mediation.
Okay, do y'all think that y'all would be ready to mediate this before December 31st, or will it be carrying over to next year?
I think that would depend on when we can schedule the depositions. There's 4 parties, so I'm not sure of everyone's availability.
Okay, Mr. Denzer or Ms. Hubert?
Yeah.
I agree with plaintiff's counsel.
Same here, Judge. We could shoot for the end of December to mediate if we can get depositions the next month or two. But discovery was just exchanged, so there's going to be at least a month before that's responded to. So I would think maybe January for mediation.
Okay, well, let's come back on December the 8th and let's see how far y'all have come. And that'll be at 9:30. Okay, anything else on this?
No, Your Honor.
No, Judge. Can we be excused, please?
Yes, you may.
Thank
Thank
you.
you, Your Honor.
Thank you, Judge.
Okay. Attorney Victor Quintanilla?
Good morning, Your Honor. I'm here on number 24 on your docket, and I believe Mr. Santos, the plaintiff's lawyer, is logged in, Judge.
That's correct, Your Honor. I'm here.
Okay, that's CL 181247-I, Jesus Zuniga et al. Versus Adrian Garcia Chavez et al. Okay, what is the announcement?
Your Honor, I represent Mr. Garcia, who we just filed an answer in May. And right now, currently, before I got involved, Judge, I'm sort of kind of at a small disadvantage. There have been some depots that have already been taken before we were involved. So what I'm doing right now, Judge, at least for my part, is I'm reviewing some records, some bills that Mr. Santos provided to me, and all for the purpose of trying to see if we can get this thing resolved. So I'm looking at maybe possibly another 45 days, Judge, before we can decide that. I may or may not have to redepose the plaintiffs from our perspective. I'm not sure yet, but at a minimum, I would need at least 45 days, either to try to resolve it amongst yourselves or possibly even go through a mediation, Your Honor.
Okay, Mr. Santos?
Your Honor, that's correct. If you recall, we had Roger Garcia, he was on the file earlier, and he had another defendant that was on board, and we resolved that portion with him. So the only thing we've got left is this last defendant. So, we've spoken and yeah, we're in full agreement as far as reviewing all the discovery and information and then going from there.
Okay, so then will you all be doing an informal mediation or are you conducting formal mediation?
Well, Your Honor, I'm going to give it a shot with Mr. Santos, and I have a very good working relationship, Judge. We're going to see if we can try to get that resolved amongst ourselves. If not, we're going to have to rely on a mediator that we can both agree on, unless the court wants to appoint somebody. But hopefully we can do that first. If not, then we'll go the other route, Judge.
Okay, I'll give you some time to try and do that. So come back on November the 3rd
Yes, ma'am.
at 9:30, and that should give you plenty of time to conclude what it is that you're doing and discuss possible settlement.
Yes, ma'am. Thank you, Your Honor. May we be excused?
Yes, you certainly may.
Have a wonderful day, Judge. Thank you.
Likewise.
Judge, I have one more case also.
Okay,
It's number 22 on your docket. This is Eric Ortega.
CL 172275-I, Erica Ortega versus Victor Bravo Salinas et al.
Yes, Your Honor.
Okay.
And I believe Mr. Guerra is here on that case.
Good morning, Your Honor. Michael Guerra here on behalf of the defendants.
Good morning. Okay, what is the announcement?
Your Honor, this is a case that it's been around for a while. Jesse Hernandez was on the file, and I know Mr. Guerra reached out to me a few weeks back that he had been assigned to the file as a result of Mr. Hernandez leaving. And we've agreed to have some conversation to see where we're at in terms of either discovery and informal mediation. And that's where we're at right now. Get this thing moving again.
That is correct, Your Honor. I'm confident that Mr. Santos and I could probably work something out on this one, but despite that, this is one that will just need a trial date. We've mediated, we've taken depositions on.
Okay, well, let's see.
That's correct, Your Honor.
You can come back on November the 3rd. And let's see where you're at that time. And then we'll take it from there. And if you'll need a trial setting, then I'll give you further instructions at that time.
That sounds good, Your Honor.
Okay, anything else?
That's all I have.
Okay.
Your Honor, I do have one
Thank you.
more on your docket.
Okay,
It's number 26 on your docket, Your Honor.
okay. And that's CL 21129-I, Francisca Luna versus Alejandro Gutierrez.
Correct, Your Honor. This is a case where, like this other one, I'm taking over for Mr. Hernandez.
Okay.
The depositions of the plaintiff is set for this week. I'm sorry, the mediation is set for 2 months from now. So hopefully we'll have a resolution, but if not, then we'll just need a trial date on this one as well.
Okay, and is Miss Padilla present? She's been making announcements on behalf of Mr. Padilla.
Yes, Your Honor.
Okay, there she is. All right, so then you all are going to be mediating this in about 60 days?
Yes, on November 18th, Your Honor.
Okay, let's come back on December the 1st and let's see how that went.
At 9:30?
Yes, ma'am.
Okay.
Okay, anything else?
No, Your Honor, that's it.
Okay.
That's all I have, Your Honor. May be excused from
Yes,
this
you
honorable
may.
court.
Yes,
Thank
you
you.
may. Ms. Carranza Hernandez, Mr. Oliveira made an announcement on your case. Are you here on Alicia Alonso?
Yes, Your Honor, number 20 on the docket.
Okay. He did give us an update, and I told him that you all can come back on December the 1st at 9:30 to see how
Okay.
far you've gotten between now and then.
Okay, thank you so much, Your Honor. May I be excused?
You certainly may.
Thank you.
Okay, Attorney Nereida Lopez Singletary.
I apologize, Your Honor. I was in another hearing with Judge Jay, and I apologize. But we are here, Judge, I am here on Adrian Cardosa, and I believe that Judge Contreras is the opposing counsel. That's on F 2799-21-9. Judge Contreras, are you there? I thought I had seen him raise his hand.
He was, yeah, he was there.
Judge, we're set for a status. It's been very difficult for me to get a mediation set with Judge Contreras. This is a case, it was a TRO with Catherine Perez. She withdrew, so at this point, Judge, we're asking for a temporary orders hearing, and it's going to be contested, Judge. I just can't get dates out of his office for a mediation.
Okay. I don't know what happened to Mr. Contreras. Do you want to, he was on, do you want to contact him? Oh, there he is. He's trying to log back in. Let me see. Mr. Contreras, I recall.
Yes, good morning, Your Honor.
Good
For
morning.
whatever reason, it cut off.
Okay, so I was just taking Ms. Lopez Singletary's announcement, and so apparently you all have had issues with trying to get some mediation dates.
No, it's not about issues, Your Honor. I've been trying to coordinate. I just have a whole bunch of other matters, and I apologize to Ms. Singletary, Judge Singletary, that is, but we can coordinate that today. I can call her right after around 11 and coordinate a mediation date on this matter. My client, though, has suggested to me that she's willing to agree outside of mediation. So there might be a possibility that I can propose something to Ms. Singletary and get this thing resolved before mediation, as far as final orders are concerned. But I'll relay that information to Ms. Singletary, and we go from there. But I can call her 11 o'clock today, Your Honor, with your permission, and coordinate the mediation date.
Okay, did you all already have a mediator assigned to you?
Yes, Your Honor. Yeah, we
Yes,
have.
Edna Cedillo, Your Honor.
Okay, so I'll give you an opportunity to coordinate that. I am gonna set you for a status for October 27th. So that gives you about 30 days to mediate and to try to come up with an agreement. If for
Your Honor,
example,
I'm sorry to interrupt. I will be going into surgery October the 18th and probably be out for at least 30 days, Your Honor. So I'm going to try to see if I can resolve it before the 18th of October and maybe submit something before the 18th. So there's an urgency at my office so we can resolve this case sooner than that date that you have given us, Your Honor.
okay, well, I just need to put something on the docket so that I keep you on the calendar.
Yes, Your Honor.
So, I mean, if you get it resolved before the 18th and you need to prove it up, let us know and
Yes,
we'll
Your Honor.
squeeze you in.
Yes.
Okay, but for now, I'll go ahead and just do the October 27th setting. And if you're not able to attend because of your recovery, just let us know and we'll work something out.
Thank you so much, Your Honor. Appreciate it.
Okay, so I'll give you all an opportunity to discuss those dates.
Yes. Thank you, Your Honor. That's all I
Okay,
have.
that's all that we have. Can we be excused?
You certainly may.
Thank
May I
you,
be
and I
excused as well?
apologize.
Yes, you certainly may. No problem. Okay, Attorney Cynthia Martinez.
Hello, Your Honor. The reason I had done this was because we're having some raise my hand was because we're having some electrical work and I was afraid that we would lose electricity. But anyway, so may I proceed with, I hope that J.R. Garza is here, the opposing counsel.
I do not see Mr. Garza present.
Okay.
I see myself, Judge. I'm right.
Oh, I'm sorry, JR. You were on. Okay.
We have case number 19. It's an agreed final protective order without findings.
Okay.
And my client, Yasmin Reyes, was supposed to be here too. I don't know. I'm using my phone because of the fact we were going to maybe lose the electricity. So I can't. Okay, she's there. She's there. Yes. May we proceed with getting the final protective order without findings put into the record?
Okay, and Mr. Garza, is your client on?
I just came on, I don't know. Eric, are you there?
Yes, I'm here.
Yeah, he's here, Judge.
Okay, and so Jasmine, can you announce yourself, please?
Yes, I'm here.
Okay, I need for both of you to raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Reyes?
Yes.
And Mr. Garza?
Yes, ma'am.
Okay, you may proceed, Ms. Martinez.
Okay, I would like to read what the, Your Honor, please, what the protective order is going to cover and then ask my client some questions, if that's agreeable to you.
Yes.
Okay, thank you, Your Honor. The state would like to introduce applicant's affidavit as states one. Would you please admit it, Your Honor?
Any objection, Mr. Garza?
Your Honor,
no.
I don't have a copy of that particular affidavit. But what I'll tell you, Judge, I apologize. I do have a copy of that affidavit. It's attached to the application. However, Your Honor, there's so much in that application that we are basically denying. I don't see a need for the application, Judge, since we are agreeing to a final protective order. So I will object on the basis that some of the affidavit is simply not true, but we are agreeing to the protective order, Your Honor. We object to that being admitted into evidence at this time.
Your Honor, it's standard for us to always ask that the applicant's affidavit be accepted as states one.
I think, Your Honor, that it goes beyond the bounds because we're agreeing to the final protective order. It doesn't really make any sense to introduce evidence when we're agreeing to a protective order, Your Honor. And let me add this, Your Honor. This protective order is a Swiss cheese protective order. It's barely hanging by strings because we objected to a lot of things and a lot of evidence that a lot of allegations that were made by the applicant. And so to come back now and to introduce an affidavit that specifically has things that we absolutely do not agree occurred would go beyond the bounds of what we were agreeing to here, Your Honor. We don't want that to be part of the record in terms of evidence as well. We're agreeing to the protective order. That should be sufficient, Your Honor.
Okay, Ms. Martinez, that protective order can be entered into a final without having the affidavit.
All right.
Put in, because the thing with a protective order, when you have a protective order without findings, then obviously there's not an agreement as to whether or not certain things occurred. However, you want the meat of that protective order to be, which is just to stay away from each other and no harmful contact.
Right.
And all of that. So I'll accept the proof of the final protective order, but if usually the affidavit will be accepted if there's a finding, because that means that everything in that affidavit is true.
Yes, ma'am. It's up to you, Your Honor. I leave it to your discretion.
Okay. I'm not admitting it into evidence. I'll allow you to move forward into the actual proof.
Okay. Yes, ma'am. Thank you. Your Honor, the parties have agreed to a 2-year final protective order without findings. The parties are the parents of one minor child. The parties will follow cause number F-2516-16-5 for custody, visitation, and child support. We are asking the court to order the respondent not to commit acts of family violence, not to threaten or harass applicant either directly or indirectly. We are asking that respondent stay 200 yards away from applicant's house, and where applicant attends school and employment. The exception is the respondent may come within 200 yards of the applicant only at the hospital where the child is having any major medical procedure and where the child attends school when the parents are picking up and dropping off their children, if their children attend the same school. All communications between the parties will be through text message only and only regarding the child. We are asking the court that the court costs be waived. We are asking the court that the protective order be in effect until September 15th, 2023. That's the extent of the agreement, Your Honor. May I ask the applicant a few questions?
Yes, ma'am.
All right. Thank you. Ms. Reyes, please state your full name for the record.
Jasmine Juliana Reyes.
Okay, did you understand the final protective order without findings?
Yes.
Did you sign the final protective order without findings?
Yes.
Are you in agreement with the agreed final protective order without findings?
Yes.
Okay, no further questions, Your Honor.
Okay, Mr. Garza, do you have any questions of Ms. Reyes?
I do not, Your Honor.
Okay, do you have any questions of Mr. Garza, Ms. Martinez?
No, Your Honor, I don't.
Mr. Garza, do you have any questions of
Yes.
your client?
Yes, Your Honor. Mr. Garza, what's your occupation?
Law enforcement. I'm a police officer.
And you carry a weapon, is that correct?
Yes.
And as a police officer, are you always on duty?
Yes.
All right. And with reference to you do carry a gun, is that correct?
Correct.
Right. And in terms of this protective order, we've agreed with the state of Texas that you're able to carry that weapon, whether you are being paid for your job or whether you are not on direct duty with the police station. Is that correct?
Yes.
All right. You have 2 weapons?
Correct. Yes.
Tell me the weapons that you have.
I have a 9mm, which is assigned to me, and then I have an off-duty one, which we also have to qualify and get approved.
Okay, so you're approved by the PD to carry the second weapon, is that correct?
Yes.
All right. All right. Your Honor, that is also part of our agreement that he's be allowed to carry a weapon while on or off direct duty, Judge.
Okay, Ms. Martinez, is that your understanding?
Yes, ma'am, that is our understanding. We do not mention anything about firearms in the final protective order without findings.
Okay, then the court will approve the final protective order without findings. And I'll ask for that to be forwarded to my queue for my signature. And I wish the parties the best of luck.
Thank you, Judge.
Thank you, Your Honor.
Okay.
Judge, after the signature, will my client be served with that protective order, or my office at least?
After I sign it, it should go back to you.
All right, Judge. Very good. Thank you, Your Honor. I have nothing further with this honorable court.
Okay. Ms. Martinez, do you have anything else?
No, Your Honor. May I be excused?
Yes, and so may the parties.
Thank you.
Thank
Judge.
you.
Thank you.
Thank you very much. Bye-bye.
Okay. All right, Attorney Aaron Fonseca.
Good morning, Your Honor.
Good morning, sir.
I have number 3 on your docket. This is an agreed divorce.
Okay. F 3029-21-9 in the matter of the marriage of Vanessa Trevino and Rene Caldera. Is Ms. Trevino present?
Yes, ma'am.
Okay, and Mr. Caldera signed a waiver of service, is that correct?
He did, Your Honor, and he also signed the final order as well.
Okay, perfect. All right, Ms. Trevino, please raise your hand, your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, Mr. Fonseca, you may proceed.
Ma'am, can you please state your name for the record?
Vanessa Marie Trevino.
And you're the same Vanessa Marie Trevino that filed this original petition for divorce, correct?
Yes, sir.
And preceding the filing, you lived in Texas for the preceding 6 months and Hidalgo County for the preceding 90 days?
Yes, sir.
And you were married on or about November 7th, 2013?
Yes, sir.
And you separated and ceased to live together as husband and wife on or about October 10th of 2019, is that correct?
Yes, sir.
And the reason that you're asking for this divorce is due to insupportability in the marriage, meaning that there's no expectation of reconciliation, correct?
Yes, sir.
And during this marriage, you had 2 children?
Yes, sir.
And you've come up with an agreement regarding those children as well?
Yes, sir.
And the agreement is that you will both be joint managing conservatorship. You will both have joint managing conservatorship, is that correct?
Yes, sir.
And you will have the exclusive right to determine the residence of the children without regard to geographic restriction, is that correct?
Yes, sir.
And you have agreed that there will be no international travel without written consent from either parent or both parents, is that correct?
Yes, sir.
Okay. And the amount of child support that you have agreed to is in the amount of $243 per month beginning September 1st, 2021. Is that correct?
Yes, sir.
With a step down to $194.40 once your oldest child emancipates. Is that correct?
Yes, sir.
As far as health insurance and dental insurance, your children they both have Medicaid. Is that correct?
Yes, sir.
So there will be a cash reimbursement. I'm sorry, there will be a medical reimbursement in the amount of $57 per month beginning September 1st, 2021. Is that correct?
Yes, sir.
And as far as visitation, you've agreed to standard, which is first, third, and fifth weekends. He will have Friday through Sunday, 6 p.m. and 6 p.m. respectively,
Yes, sir.
and alternating holidays per the family code, correct?
Yes, sir.
And as far as the division of the property, you have agreed to essentially keep everything that is in your possession and subject to your sole control, correct?
Yes, sir.
And that includes a 2018 Nissan Maxima motor vehicle, correct?
Yes, sir.
And as far as the debt, we're going to follow the same format. Each keeps their own, along with the debt on that Maxima. Is that correct?
Yes, sir.
And there's no need to change your last name. Is that right?
No, sir.
Okay. And are you asking this court for divorce?
Yes, sir.
I have no further questions, Your Honor.
Okay. Then the court will approve the divorce and grant the relief as requested and testified to on the record. And I'll ask for that divorce decree to be forwarded to me. Have you e-filed it yet?
Your Honor, I e-filed it, but it was returned. I think we filed it a little bit early. So what I can do is I can re-upload or resubmit it today as soon as this hearing is over.
No, if it was returned by the court, Ms. Castañeda can request for it to be sent back. It's not necessary.
Okay, then.
Okay, so I'll request for that to be sent back to our queue and I'll go ahead and sign off on it.
Perfect. Thank you, Judge. May we be
Okay,
excused?
yes, best wishes to you, Ms. Trevino.
Thank you so much.
Okay,
Thank you, Judge. Have a nice day.
likewise, you too. Okay, Attorney Gilbert Vasquez.
Good morning, Your Honor. I'm here on number 36 of your civil docket, Your Honor.
Okay,
Good morning,
that's
Judge.
F.
Present on behalf of them.
Okay, I'm sorry, F 3326-04-9 in the interest of minor children. Okay, I'm sorry, who was also here?
Good morning, Judge El Romero, present on behalf of the Office of the Attorney General.
Oh, okay. Okay, and Mr. Vasquez, is the respondent still pro se?
I believe so, Your Honor. And just for the record, my name is Gilbert Vasquez, and I'm here on behalf of my client. Her name is Irene Jeanette Rodriguez, Your Honor. And she's present. I haven't seen him online, Your Honor. His name is Ricardo Rodriguez.
Okay, Mr. Damien, will you please call out that name 3 times?
Yes, ma'am. Ricardo Rodriguez. Ricardo Rodriguez. Ricardo Rodriguez.
Okay. You may proceed. I believe we're here on the OAG's request.
Actually, Your Honor, I filed a motion for enforcement in order to appear in this case back in 2019. We were in County Court 2. We were trying to make an agreement and try to finalize this case, but we were unable to. So we were just asking for a final hearing. I believe today it's just set for status, correct?
Yes, but I have it that it's set for status because I think the OAG's office had requested it.
Oh, okay, okay.
Okay,
Great.
so Ms. Romero, was there an announcement that you needed to make on the case?
Judge, just for our purposes, there are some arrears and we will be looking to take a judgment and set the respondent on a payment plan, but we will be able to proceed with that when Mr. Vasquez and the parties are ready to go forward on their motions.
Okay, so then you want a final hearing on your motion for enforcement, Mr. Vasquez?
Yes, Your Honor.
Okay, let me see. Okay, and how much time do you need, sir?
30 days, that would be fine, Your Honor.
Okay. Can you please go ahead and do an order setting final hearing with the date October 27th at 11 a.m. and make sure that all the parties are CC'd on that?
I will do that, Your Honor. I apologize, Your Honor. I'm going to be in Mexico supposedly in October. Oh, no, I won't be gone by that. No, I'll still be here, Your Honor. So
Okay.
that's fine. So it's October the 27th at 11 in the morning, Your Honor.
Yes.
Your Honor, and I do notice on the order setting hearing today, I guess Mr. Ricardo Rodriguez moved and there's a new address on this order setting hearing. It's 1414 Spear Street, Westlaco, Texas, 78596. That's where I'll be sending him notice, and I can also attach the old address that we've been using in the past. I'm not sure where that address came from.
Okay, I don't know. He may have updated it with the OAG's office.
Okay.
I'm not sure.
Okay, Your Honor.
Mr. Romero, do you show anything on your record?
Judge, Your Honor, I'm verifying. Yes, Judge, I do see that his address was updated in our system, and it was probably due to that address was included.
Okay. Then I will send it to that address, Your Honor.
Okay, no problem. Then we'll go ahead and see you all back here on October 27th at 11 a.m. for final disposition.
Great, Your Honor. Thank you very much, Your Honor. May my client and I be excused?
Yes.
Thank you, Judge. May I also be excused?
Yes, ma'am.
Thank you, Judge. Good seeing you.
Good day.
Likewise, Attorney Jose Osuna.
Good morning, Your Honor. Jose Osuna for the record. I have number 31 on the court's docket, F 2415-19-9, in the matter of the marriage of Julissa de Leon Sanchez and Jose Monreal. Ms. Sanchez is on. I've had one conversation with her. She appeared more comfortable in Spanish, so she may need an interpreter.
Okay. Let me see, Julissa de Leon Sanchez.
Yes, sir. Yes, ma'am.
Okay, just ask her, Ms. Castaneda, if she's more comfortable in English, we can Spanish, we can translate for her.
Ms. Sánchez, ¿prefiere la conversación en español para traducirle?
Claro que sí.
Yes, ma'am.
Okay, all right, and Mr. Osuna, what is the status on your role as the ad litem?
Yes, Your Honor, I confirmed with Ms. De Leon. She seemed to have misunderstood what her obligations were in order to serve by publication. There is no sworn statement as required by the code, as far as I can tell. She also did not engage in any recent appreciable search for the respondent. I engaged in a cursory search forum. I haven't been successful yet, but before I got too far along, I at least wanted to report that much to the court and see if the court had any guidance moving forward. But I do believe that service so far is defective for the reasons described.
Okay. So Ms. Castaneda, explain to Ms. Sanchez, please, that when because she wants to serve by citation, by publication, there's certain things that she needs to do.
Ms. Sánchez, porque usted quiere servir al Señor por publicación, hay ciertas cosas que usted tiene que hacer.
One is an affidavit outlining her efforts to locate Mr. Monreal.
Una es que tiene que hacer una declaración jurada de de dónde está el señor Monreal.
Okay, está bien.
Okay, that's fine.
So is that something that may be a little complicated for her and she may want to seek legal counsel?
Eso es algo que está un poco complicado para usted y a lo mejor va a necesitar representación legal.
Es que yo ya le había dicho al señor Osuna que yo no tengo contacto con él.
I had already told Mr. Ozuna that I don't have any contact with him.
I understand that, but she still has to meet the requirements by the code in order to do the citation by publication.
Yo entiendo eso, pero todavía tiene que seguir los requisitos para hacer la publicación del anuncio.
Ok, necesito hacer entonces, ¿qué? Perdón.
What is it that I need to do?
Well, it's not only the affidavit, there's other things that she needs to do. That's why that it's a little complicated.
Pues no nomás es la declaración, hay más cosas que tiene que hacer, por eso le estoy avisando que es un poco complicado.
Está bien.
So, I know that her resources are limited, but I suggest that she seeks legal counsel.
Yo sé que sus recursos son limitados, pero yo le sugiero que consiga que consiga consejos legales.
Está bien.
Okay.
Okay. I'm going to give her an opportunity, Mr. Osuna. Hopefully she can hire somebody, because if not, I mean, your hands are going to be tied. I mean, it's not your job to make sure that she covers, I mean, your job is to oversee everything, you know, and to make sure that she did what she needed to as far as following the required, the requisites in the statute. But it's not for you to advise her on how to go about doing it. You're not her attorney. So I'm going to give her an opportunity to do that. So Ms. Castaneda, tell her I'm going to give her an opportunity to see if she's going to seek that legal counsel, and I'll reset her to November the 3rd, and that'll give her enough time to do that.
Le voy a dar una oportunidad para que se asesore legalmente y le vamos a regresar el día 3 de noviembre.
Ok, pero si no tengo dinero suficiente para agarrar un abogado, ¿cómo le hago?
If I don't have enough money to hire an attorney, what do I do?
Well, she's not meeting the requirements, so I'm assuming she wouldn't be able to go through with the divorce.
Pues no está haciendo los requisitos, so no se puede divorciar hasta que haga los requisitos que está pidiendo.
¿Y cuáles son los requisitos?
We cannot give her any legal advice.
No podemos darle consejo legal.
Ok, bueno.
Tell her to look into legal aid.
Puede buscar con legal aid.
Ok, está bien.
Okay, that's the best that we can do. Okay, tell her we'll see her back here November the 3rd at 9:30.
Regresamos el día 3 de noviembre a las 9:30 de la mañana.
Está bien.
That's fine.
Okay, Mr. Osuna, anything else?
Your Honor, may I call number 4 on the court's docket, CL 20-3480I?
Yes, I have that was reset to October 27th at 9:30.
Yes, Your Honor, that was our understanding. I just wanted to make sure that it was, that I just noted it so it didn't stay on the docket.
Yes, sir.
All right, thank you, Your Honor.
Okay. Attorney Hector Bustos.
Good morning, Judge. Hector Bustos for the record, Judge. I got number 14 on your civil docket, Judge.
F 2318-15-9 in the interest of a minor child.
Yes, Judge. I represent Mr. Ismael Valdez. He is present, Judge, through Zoom, Judge. I was looking at it, Judge. I believe we're set for a hearing for substitute service by citation by publication. However, I was looking at the pleadings. I wasn't the original attorney. Orlando Jimenez was, and I think that it was a motion for enforcement and access to a child. However, I'm going to amend the pleading, Judge, and file for a motion for modification of the child custody, Judge. So I'm going to go and ask the court if I can go in and pass this hearing, Judge. That way I'm still going to have to serve her through a citation on the modification, Judge. So I think that in the interest of time, Judge, if we could pass this hearing.
Okay, so then it's unnecessary to have the hearing then on the motion.
Yes,
Okay. All right, then I'll just,
Judge.
okay, I'll just wait for you to file that then.
Very well, Judge. Thank you, Judge.
Okay.
Excuse?
Yes, sir. Attorney Robert Bettis.
Good morning, Your Honor. I have a number 11 on your docket. It's a motion for substituted service.
CL 21-1963-I, Mario Espinosa et al. Versus Michelle Garcia. Okay,
Yeah, we tried to serve the defendant, and somebody answers the door and says, you know, they don't want to have anything to do with us. We went out there 5 times, so we're asking the court to allow us to just drop it off with anybody 16 years old or older.
okay, and is the affidavit on file and state what you just put on the record?
Yes, it's attached to the motion.
Okay. It's because I said earlier, I'm having issues with my Odyssey, so I can't get into it right now, but I don't have time to reset it. So, okay, well then that'll be granted so long as the affidavit has the requisites that the statute requires. Is there an order on file?
There is, Your Honor.
Okay, I'll ask for that to be forwarded to my queue and I'll sign off on it.
That's all I have. May I be excused, Your Honor?
You certainly may.
Thank you.
Okay. So the rest of the attorneys that I have on the screen, are they all contested issues? Yes, okay. Okay, let me start with, I'll get you as I see you. Okay, Attorney Michael De Leon.
Good morning, Judge. Judge, they're not really contested issues. The first case that I have, I believe it's number 21 on the court's docket, Julio Quintanilla versus Allstate.
Okay, CL 151588-I, and I did see Miss Sandoval present earlier.
Yes, Judge, I have been texting with her. She had to step out. She's currently, I believe, in a deposition. But it's just a simple announcement in this case. We have, this case is in a print. We get the award back from the court-appointed umpire, Pablo Sunny Garza. We got it back, we got the award last Thursday. So we're just gonna be asking for a reset, probably about 5 days. We get payment of the award. I just forwarded the award to Ms. Sandoval this morning.
Okay, so you just need to reset this for a week?
No, probably about, I would say about 45 days. Judge.
Oh, 45 days. It's because you're freezing, so I heard 5 days.
Yeah, no, 45. I'm sorry. I think I'm having some technical difficulties over here.
Okay, then it'll be November 1st at 9:30.
Hey, Judge, I do have one more case. I'm standing in for Attorney Willie McCallan. It's number 23 on the court's docket, CL 173652-I, Raul Martinez and Sylvia Martinez versus Southern Vanguard and certain underwriters at Lloyd's.
Okay, and who is the defense counsel present?
Your Honor, I'm here, Elizabeth Herrera for Jaime Signs, and we represent certain underwriters at Lloyd's London.
Okay. All right, and what is the announcement?
Your Honor, my understanding of speaking with Mr. McCallan, this I believe is a status hearing. I believe the court has already signed an order to mediate this case, and Mr. McCallan was looking to mediate this case within the next 45 to 60 days.
Yeah, good morning, Your Honor. In looking through this case here, we're going to be having a motion to dismiss filed here within the next 2 weeks on behalf of our client. So we would ask that the court defer ordering us to mediate for a time to provide us with an opportunity to get that on file with the court.
Okay, I believe I already signed the order granting the motion to mediate, but you can still file your whatever pleadings you need. But I still need to set you for a second status. I still need to set you for a second status so I don't lose you. And if you file a motion to dismiss between now and then, we'll go ahead and set it for you.
Yes, Your Honor.
Okay.
We would suggest then a reset
of
30 to 45 days for follow-up status.
Okay, Mr. De Leon, you were saying, I'm sorry?
We would still like to compel them to mediation, Judge.
Okay, so I'm gonna have y'all come back also on November the 1st at 9:30. There is an order already on file, so you all work that out. And if you're not going to go to mediation within that time, then file your appropriate pleadings.
Yes, Your Honor, thank you.
Okay, anything else?
I have another case.
Your Honor, I have nothing
I'll let,
further.
Okay, Mr. De Leon, if you have nothing further, you may be excused.
And I have another case if I can go out of order, Your Honor. I'm here also on number 7 on the court civil docket, representing Walmart, defendant Walmart.
Okay, CL 183101-I, Jorge Lozano versus Walmart et al.
And I don't see Steve on here, and he has not advised whether or not he opposes my motion that this case be referred to mediation. But I would ask that Your Honor order that this case be mediated within the next 60 days. And I can follow up with Steve to confirm an agreed mediator.
Okay, the court will grant your motion for this to be mediated within 60 days, and the court will send out the order of referral.
Thank you, Your Honor.
Okay.
And
Anything
that's all
else?
I had. May I be excused?
You certainly may.
Thank you, Your Honor.
Okay, Attorney James Sahadi.
Good morning, Your Honor. Here on number 9 on the docket, CL-20-1935-I.
And Your Honor, my name is Scott Red. I'm here for the movements on number 9 on the docket.
And Judge Chester Mikowski for the CC Pizza defendants here.
Okay, and what is the announcement?
Your Honor, we represent Artesera group, and both of these motions are brought by Artesera. One is a motion to designate responsible third parties, where we've adopted actually the motion that was filed by CCRGV and CC Valley Inc., DBA CC's Pizza. The other is a motion to compel discovery responses, which we have solely filed on behalf of Artesera Group.
Okay, so then how much time are y'all gonna need to argue these two motions?
I think they're pretty straightforward, Judge. The motion to compel, there's a little bit of history there, but I believe that Artesera is requesting that the discovery be produced or served within the 7 days. We're just requesting just a little bit more time, Judge. It's been my intent to file a motion to withdraw as counsel for the plaintiff, but I didn't want to do so without having answered the discovery. And one of the issues that I've had with my client was being able to get a hold of her, but I've reached out to a family member, and I'm confident that I can have her come in, get these answers and responses produced and filed, or rather served to defense counsel. I'm just asking for a little bit more time than the 7 days that they're requesting.
Your Honor, we certainly empathize with counsel. Our discovery was served September 24th of 2020. And it's been a mighty long time. We need the responses. We have a duty to our client to defend our client properly. And part of that is to do our due diligence to obtain the information that we requested. No objections were filed, and we're coming up on a year, and we have answered to our client as well. So we would appreciate the 7-day order, or maybe 14, but no more than that.
Okay, and how much time were you asking for, Mr. Sahadi?
2 weeks, Judge. 14 days is fine. We should be able to get that discovery out.
Okay, so Mr. Red did say that no more than 2 weeks. So we'll go ahead and give you the 14 days Is that from today's date?
We would ask that, Your Honor.
That's fine, Judge. We'll have that discovery out.
Okay, so that'll be 14 days from today's date. And anything else?
Yes, Judge, on that responsible third-party motion, that is unopposed as far as I understand. We had filed it first back in March, and nobody voiced any opposition to it. So I think that'd be good to go, quite frankly.
I agree.
Okay. Mr. Sahadi, any opposition?
Not at this time, Judge. We'll follow a motion to strike if need be later down the line after the further discovery is conducted.
Okay, so Mr. Makowski, do you have an order on file, sir?
We do have an order on file, Judge.
Okay, I'll ask for that to be forwarded to my queue then.
Great. Thank you. May we
Thank
be
you, Your Honor.
excused?
Okay, and also on your order to compel, I'll go ahead and revise that and insert the date certain.
Thank you, Your
Thank you,
Honor.
Judge.
Okay, anything else, gentlemen?
Nothing
No,
further,
Judge.
Your Honor.
Okay, y'all have a good day.
Thank you very much. You too.
Thank you.
Yes. Okay, Attorney Diana Fuentes Aguilar. Okay, Attorney Fela Olivares.
I'm here, Your Honor. Good morning.
Good morning, ma'am. How are you?
Fine, thank you, Your Honor. How about yourself?
Doing well.
Good.
Okay, what number?
I don't know the number, Judge, but it's the Miranda, in the interest of the Miranda children, the F 2822.
Okay, that's number 15 on the court's docket, F 2822-16-9. Okay, and is this still a default final hearing?
Yes, Your Honor. And for the record, Mr. Miranda has been served for quite a while. He was served on January 13, 2020, returned was 1/15/2020. We do have default temporary orders, which we're actually going to implement into our default hearing. If the court wants to call out his name just in case, but I do not see any answers or any type of response.
Okay, Mr. Damian, will you please call out his name 3 times?
Yes, ma'am. Hector Miranda, Hector F. Miranda, Hector Miranda.
Okay, the name being called out 3 times and no response. Okay, so then he was served on January 13, 2020, and the notice for today's hearing, was that also sent to him?
No, Your Honor. Once he's, if he hasn't responded, then it's a default. What I did is I already filed that certificate of last known address, and I filed a military affidavit, and we have the default decree. As soon as I prove it up, we'll e-file it for the court.
Okay.
And there's just minor changes. It's excuse me, it is a modification for possession and access.
Okay, and so you're going to finalize the default temp orders then?
Yes, that's correct.
Okay, let me have your client. Is she English or Spanish speaking?
English is fine. Yes. Can you see her, Judge?
Yes, I can.
Okay.
She's good.
Okay.
Okay, will you please raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead.
Yes, thank you, Your Honor. Would you please state your full name for the record, Miriam?
Mariam Millan Martinez.
And Miriam, we filed a petition to modify back on October 10th, 2019. Is that correct?
Yes.
And you already heard that Hector, the father, Miranda, was properly served.
Yes, ma'am.
Okay, and we did enter, for the record, we did enter final, we entered default temporary orders also. He did not appear or filed a response to your knowledge. Is that correct?
Yes, ma'am.
Okay. And the only thing that there were 2 things that you modified in the divorce decree that that was modified, and that decree, let me see if I have the information here. It would be in my pleading. Okay, and what you modified was the possession and access for the children, Kevin and Javier Miranda. Is that correct?
Yes, ma'am.
Okay. And let me read it. You ordered that, you requested the court of temporary orders in which we are implementing and adopting them, that they will no longer be overnight visitations with the children, and that future visitations shall be supervised by respondent sister Jeanette Miranda. Is that correct?
Yes, ma'am.
And it is also ordered that the visitations are first, third, and fifth Saturday and Sunday from 2 p.m. to 5 p.m. at Peter Piper Pizza on Conway in Mission, Texas. Is that correct?
Yes, ma'am.
Or at another public place mutually agreed by you and him.
Yes.
Okay. And you have requested also to the court that he abstain from consumption of alcohol or any controlled substance within 12 hours before the access is possession of the children. Is that correct?
Yes, ma'am.
Okay. And also, since he seldom does visitations, you've requesting the court that he provide to you 24-hour notice prior to exercising any visitations. Is that correct?
Yes, ma'am.
And we are not changing the child support. It remains the same. Is that correct? The 506?
Yes.
And that was back on August 1st, 2020, correct? All right. And there's a step down. The next child support would be 506 if the first child emancipates.
Correct.
And there was a judgment for child support arrears, and this one, you've printed the summary, and we will submit it as evidence for the court from the Attorney General. Is that correct?
Correct.
He has been in arrears as of September 14, 21, $19,111.42. Is that correct?
Yes.
And you are asking the court that aside from the child support, that he pay you $150 per month on this judgment until fully paid.
Yes, ma'am.
Is that correct?
Yes, ma'am.
Okay. And everything else remains the same in regards to your decree that was not modified this morning. One other thing, is that correct?
Yes, ma'am.
And the cash medical, did your insurance change? You're carrying the insurance,
I
correct?
carry the insurance, correct.
And what is the premium that is current right now?
$244.
And you're asking the court that he reimburse you that amount of $244 for the cash medical, is that correct?
Correct.
To you,
Yes.
because you're providing it through your employer.
Correct.
And is there anything else that I have not mentioned, your injunction relief? We still have in the temporary orders, you had requested a permanent injunction that the court also granted, and you're asking that it remain in place only as to you,
Yes, ma'am.
that he not contact you in a harassing manner, that he not, or a threatening manner, that he not go to your place of business, employment, is that correct?
Yes, ma'am.
And disturbing the peace of the children or withdrawing the children from the schools without your consent. And of course, there's 7 of them, and they're listed on page 22 of the modification. Is that correct?
Yes, ma'am.
And you're asking the court to grant you this default order with these modifications that you read into the record.
Yes, ma'am.
And for the record, have you seen Hector Miranda lately?
No, I haven't. In a
And
very long time.
when was the last time you saw the children?
The last time he saw the children was probably February of 2020.
Okay, all right. So it's been over a year, almost a year and a half that he has no contact with the children.
Correct.
Is that correct?
Correct.
Okay. Thank you, Your Honor. That's all I have.
Okay, the court will approve the agreement as read into the record. And that'll be set forth in further detail in a final order. Have you submitted that order yet?
We will, Your Honor. I read off of it. And Your Honor, may I just ask the court, you used the word agreement. And that means the other party is present. So I just want to clarify that it's a default order.
Yes, I stand corrected. Let the record reflect that Mr. Miranda was properly served and did not appear. So this is a default final hearing. And so I will approve the terms as testified to into the record.
Yes, Your Honor. And that's all I have, Your Honor. Thank you very much.
Okay, and I'm gonna go ahead and set a tickler for, you're gonna submit that order by when, Ms. Olivares?
Right now. because she's
Okay.
here. We'll
All
send
right.
it right now.
Okay, then as soon as it comes through, I'll ask for it to be sent, but I'll still set a tickler for September 24th.
Thank you very much, Your Honor.
Okay, thank you.
Thank you. Have
Okay.
a nice day.
Likewise, Attorney Reggie Richardson.
Good morning, Your Honor.
Good morning.
I have number 33, I believe.
Okay.
Good morning, Your Honor. This is Leo Pruneda, and that's if it's case with Poirier, then I'm on that case as well. F32.
Mr. Pruneda, I'm sorry, but Mr. Pruneda,
12-9. Is that the one, Ms. Richardson?
Mr. Pruneda, we cannot
Uh-huh.
understand what you're saying.
Yes,
You have
ma'am.
a really bad connection.
Yes, I think
Your Honor,
so.
I believe he was reciting the case number F3270-12-9, Poirier Aviles. For the record, Judge, she is present on Zoom with her father, Pedro Aviles. Your Honor had heard this case. This is a transfer. We were here prior with Ms. Ortiz, Vanessa Ortiz, Ms. Aviles's mom. The court had asked for a report from me, and Your Honor, I'm here for some guidance. I attempted contact with mom that I understand. I don't know if the court recalls, Ms. Ortiz had stated on the record that at some point she had been in Mexico. And then I think at the time of the hearing, she was here. Ms. Poirier has indicated to me that she thinks her mom may be back in Mexico. So for purposes of what the court would consider in terms of final orders, at this time, I can represent to the court that I've not been able to have any contact, much less meaningful contact with Ms. Ortiz. She did express that she wanted more access to Poirier. I've spoken to her, to Ms. Aviles, Poirier Aviles, Your Honor, and she is a bright and charming and vivacious young lady. She has represented to me that she is thriving and doing extremely well with her dad. She has what she needs to attend school. She's back in person. She's indicated that her grades are A's and B's. But I don't know, given Ms. Ortiz's absence at this proceeding, how the court would ask me to proceed with regard to final recommendations.
Okay, so I do recall that Ms. Ortiz was present, and I remember vividly what she was stating. But to me, if a parent is having is stating that they have an interest in playing a bigger role in their child's life, or that they want more access to them, then they have to show it. They have to show it to you too, and they have to show it to their child, and that's not what she's showing. She did have notice of today's hearing. The last time she was actually in Mexico when she was doing the Zoom hearing, so she has internet connection wherever it was that she was in Mexico. What I would say, Ms. Richardson, is that your hands are pretty much tied and you can only work with the information that is in front of you. And so if she doesn't make herself accessible to you, and you're comfortable with what you do have and making a final recommendation, I'm fine with it.
Okay.
We can proceed, because we can't be waiting for her to decide when it is that she's going to make this hearing a priority.
And Your Honor, if I may add, I spoke with Poirier yesterday, late afternoon. She said that she had spoken with her older brother, who indicated to her that Ms. Ortiz is still in Mexico, has no intentions of coming back to the U.S. Anytime before December. Apparently, she's trying to make a living over there with her living boyfriend, husband, and that, well, she has no intentions of coming anytime soon prior to December.
And Judge, just obviously for Your Honor's consideration, that's coming third hand from her brother. She did indicate that to me, but I understand where Your Honor is going. I just wanted to make sure that I'm following the court's protocol with regard to proceeding to anything that would be final given her absence. I didn't know if the court wanted to engage in another notice to her, or whether we can proceed today, and that's the guidance I was asking for from the court.
Okay, well, I think the best that you can do is just with what you have in front of you. So we can go ahead and set this for a final hearing if you'd like, Ms. Richardson.
Yes, Judge, that's fine.
Okay, how much time do y'all need in order to get what your recommendation, Ms. Richardson, to Mr. Pruneda, so y'all can have a final order for all of you to sign off on?
Judge, I would say no more than a few weeks. I already have the information. Now it would be just a matter of the practicalities of verbiage and things like that. But I would say a few weeks plus. We do have, that I know of, a working email address for Ms. Ortiz, so she can be noticed and provided a copy in advance, just so that we're all, so that, you know, Corey doesn't have to come back for notice reasons and things like that. I'd like for her to just sort of continue on a really good path that she's finally at right now.
Okay, so let's come back on October the 27th.
Your Honor, excuse me, I think I already have a conflict on that date. So
Okay,
27th wouldn't work for me.
November 1st.
That'll be fine, Judge.
Okay, let's do November 1st, but at 11 a.m.
Very well.
And if you can do me a favor, Mr. Pruneda, and do an order setting final hearing with the date of November 1st at 11 a.m.
Very well. I'll get that out to you this afternoon, Judge.
And then just go ahead and CC all the parties, including Ms. Ortiz.
Very well.
Now, the child does not have to be present. I don't want her missing school.
Very well. Okay, thank you, Your Honor.
Your Honor, would Your Honor, is Your Honor requiring Mr. Aviles to be present as the parent?
Yes.
Okay.
Yes. Okay, so November 1st at 11 a.m.
Very well.
Ms. Richardson, if Ms. Ortiz does not pay her fees to you, have judgment language in
Yes,
that
Your Honor.
order so that you can enforce it if you choose to at some point.
Certainly, Your Honor. I appreciate that.
Okay,
Yes, Your Honor.
anything
May I-
else?
No, Your Honor, not on this matter, and that's all I have this morning. May I be excused?
Well, I
Okay.
just want to add that I've known Ms. Richardson for quite some time, and she has done a marvelous job on this case, Judge.
Thank you. Correa was easy. She's great.
I'm sure Ms. Richardson appreciates the compliment.
Thank
Okay,
you.
good.
Thank you. Have a
Y'all
good day.
take care.
Thank you.
Thank you.
Okay.
Bye-bye.
All right, Attorney Diana Fuentes Aguilar.
Good morning, Your Honor. I'm representing Iris Arroziola on number 1 on your docket.
Okay, F2677-21-9 in the matter of the marriage of Iris Arriazola, Arreazola, versus Mr. Ukegbu, Ukegbu.
Yes, Your Honor. And Your Honor, my intention today was to proceed on a default. Mr. Ukegbu is present. Looks like he's in the car. And I'm not sure what his intentions are today. I'm asking to proceed.
Okay, Mr. Ukegbu, would you like are you going to be representing yourself today, sir?
As at the moment, yes. I tried to be able to reach out to Ms. Fuentes' law office to be able to see if we could be able to do something outside of here, but I was not able to receive a phone call back. I reached out to her office on 2 occasions. However, I was not able to get any response back since I was able to get served.
I don't see that he's called, Your Honor, but I will check with my staff. If, Judge, are you able to put us in a breakout room and maybe I can, because I don't think this is going to be complicated, but it might be. I need to see what Mr. Ukegbu intends.
Okay, yes, I can do that. Hold on. I'm gonna go ahead and assign you all to a breakout room. So you're gonna see an invitation on your screen, Mr. Ukegbu, and then you'll need to accept it. Ms. Fuentes Aguilar, do you want your client in that room as well?
Yes, Your Honor.
Okay. I'm assuming she's Iris's iPhone?
Yes.
Okay. Okay, you should see the invitation on your screen. Okay, Attorney Ben Gutierrez.
Good morning, Your Honor.
Good morning, sir.
I am here on 2 motions for default judgment.
Okay, what's your first, which one is your first case? What number are you on the court's docket?
I don't have the docket, Your Honor, so unfortunately, I can give you the cause number or styling, but I don't have the docket number.
Okay. I know you all get these assigned to you sometimes at the last minute. Tell them to send you the docket as well, because I do require for y'all to know your number. So which one is the first? Is it, what, give me the case number.
I got CL-19-5132-A.
Okay, it's now I. That's number 8 on the court's docket. Government Employees Insurance Company versus Jose Luis Velasquez.
Yes, Your Honor.
Okay, give me one moment. My Odyssey is working now, so. Okay, so what I have, I do see that the motion for default judgment was the one that was filed on February the 3rd, 2020. Is that correct?
I believe so, Your Honor. Yes.
Okay. Okay, all right, you may proceed.
Your Honor, we're asking, may it please the court, Benjamin Joseph Gutierrez on behalf of Geico. We're asking for redress from this court and the motion for default judgment. And we're relying on a business records affidavit that was provided to the court in December of 2019. We filed this petition in September 2019 and the defendant was served in October 2019. There's been no answer. We filed the motion. We provided a certificate of last known address to the defendant, along with the related SACRA information and an affidavit testifying to the fact that the defendant is non-active duty military status. We're asking general damages in the amount of $16,396.86 plus court costs. There's an affidavit in support in the default judgment that attested the details, including attorney's fees in the amount of $500 and applicable post-judgment interest of 5%, Your Honor.
Okay, did you say that there was an affidavit of non-military status on file?
It's I believe it may be in the affidavit in support of default judgment. I think that's the way it's titled, testifying to that.
Let me see. Okay, they put it all together in the motion.
Yes, Your Honor.
Okay. Just for, okay, they put it all together in the motion. All right. Okay, so the court will take judicial notice of all the documents in the court's file, specifically that the defendant was served on October 15th. No, I'm sorry, that the defendant was served on October 11th, 2019, was filed, the service was returned to the court. There is no answer on file. Mr. Damien, please call out the name Jose Luis Velasquez 3 times.
Yes, ma'am. Jose Luis Velasquez. Jose Velasquez. Jose Velasquez.
Okay, the name being called out 3 times and no response. The court will grant the relief as requested. And is there an order on file?
I believe so, Your Honor. If not, I can make sure to e-file it.
Let me see.
Judge, there's one on March of 2020.
Okay, yes, it was on March 3rd, 2020. That's the one that needs to be forwarded to my queue. Okay, and what is your next case?
It is CL-21-0035-I.
Number 10, Judge.
Okay, that's Bank of America versus Erica Zapata.
Correct, Your Honor.
Eric Zapata.
Yes. There's no A.
Let me pull that up. Okay, you may proceed.
Your Honor, may it please the court, Benjamin Joseph Gutierrez on behalf of Bank of America. So this is a Coach Lambert case as main counsel. I know that with Hurricane Nicholas and such coming through, they've been having some issues with the servers. So I have minimal details. I know when the motion was filed, but the servers couldn't connect, so I didn't see the actual motion details in it. The petition was filed January of this year, and there's a proposed order, but I have little details other than that. So I don't know if it's best maybe to reset unless the court wants to take this case under submission.
Okay. No, I can't take it under submission, but I'll give you time. How much time do you need?
A short reset, Your Honor, maybe two weeks to a month, if that.
Okay, the earliest I have is October 27th at 9:30.
Understood. Thank you, Your Honor. I have nothing further from the court.
Okay. Okay. Thank
Thank
you.
you.
Have a good day. Okay, Attorney Juan Ramos.
Good morning, Your Honor. Can you, sorry, I'm having technical issues. Can you hear me?
Yes.
Yes, Your Honor, I'm here. Let me get that cause number for you real quick. I'm here on number 16 on your docket.
Okay, that's F 3895-19-9 in the matter of the marriage of Roel Saavedra versus Idolina Rubio.
Yes, Your Honor, Juan Ramos here on behalf of the petitioner, Mr. Roel Saavedra. Your Honor, we're set for a motion to consolidate this morning because there was a separate child support action that was commenced prior to the divorce. So I spoke with opposing counsel and we're both in agreement to consolidate the child support case into the divorce.
Okay, so what's the child support case number?
Your Honor, the child support case number is, let me get that for you. I apologize, Your Honor, I just had it here right now.
Okay.
Your Honor, the child support cause number is F-3415-19-9.
Okay. So does the order reflect that this will be consolidated into the divorce?
Yes, Your Honor.
Okay,
The child support action is also in the same court.
okay. So then do you have an order on file?
Yes, Your Honor, we filed a proposed order as well.
Okay. Then I'll go ahead and did both of you sign off on that order?
No, Your Honor, but I can get Mr. Morales's signature to help with that.
Okay, no, that's fine as long as you put on the record that there is no opposition to your motion.
Okay, we'll make sure to file one.
Okay, so do you want to file one with the signature or do you want to put on the record that there's no opposition?
Oh, I'll put on the record that there's no opposition, Your Honor,
Okay.
to facilitate.
Then I'll ask for that order that's already on file to be forwarded to my queue. And who was opposing counsel on this?
So, Your Honor, when we filed it, it was actually Mr. Rolando Cantu, but since then, Mr. Osvaldo Morales has come into the case.
Okay. Do you know if he filed a motion for substitution?
Yes, Your Honor, he did, and I believe it's kind of odd, but on Odyssey, even though the substitution's been granted, it has both attorneys listed.
Oh, okay.
Your Honor, I'm sorry. That order granting on the motion to consolidate has only Mr. Rolando Cantu's information and Mr. Ramos. It's not Mr. Morales.
Okay, Mr. Ramos, you'll need to file an amended order because it doesn't have Mr. Morales's info.
We'll
The
make
order,
sure to,
yeah, the order you have on file has Mr. Cantu's.
okay, we'll make sure to take care of that, Judge. And since I'll be refiling an order, I'll just go ahead and get Mr. Morales's signature as well.
Okay, then I'll go ahead and set a tickler for September 24th for it to be submitted.
Will
Okay,
do,
anything else on this matter?
Nothing further, Judge. May I please be excused?
Yes. Oh, Ms. Rubio, were you saying something?
Was I supposed to be here for the?
It's not necessary because it's a motion to consolidate, but you're certainly welcome to attend any hearings that you're a party of.
What is it that we did today?
It's because you have two cause numbers, one for your child support and one for your divorce, and you really should only have one.
Yes,
So
I asked for child support before he gave me the divorce order.
yes, so all we did was just consolidate that into your divorce. That's it.
Okay.
All right.
Perfect.
Okay, y'all have a good day.
Thank you.
Thank you, Judge.
Okay. Oh, Mr. Ramos,
Yes, Your Honor.
while I have you on, is your contested hearing this afternoon still on?
There are some logistical issues that came up with service related to COVID. So unfortunately, we have not been able to serve the respondent. So I do not believe it's going to be possible to have a hearing.
Okay, if you'll just come on and make that quick announcement.
Will do, Judge.
Okay, thank you. Okay, Attorney Lucy Williamson.
Good morning, Your Honor. We're here on F 1362-12-9. And I represent Elizabeth Carranza Cabrera.
Okay. And is Mr. Martinez, this is a final hearing on a motion for enforcement, is that correct?
That's correct, Your Honor. I don't see him on the screen. I know he was previously represented by counsel a few months back that withdrew. At our previous hearing, he represented himself. But I don't see him on the screen, Your Honor.
Okay, he has notice of today's hearing, is that correct?
That is correct, Your Honor. Your Honor, and I've got to tell the court, I've been trying to get a hold of him for some time now. He doesn't, he doesn't communicate with me. I've even tried him this morning. It goes straight to voicemail. He doesn't pick up. He did just text right now, my client, and saying he wasn't given any information. I mean, I feel compelled to tell the court that he does. We
Okay, so
have,
I recall that when he was here and he stated that he was gonna be on his own, I did tell him or admonish him to make sure he stayed in contact with you.
and he did not.
Okay. The only thing is that, did he provide us with an email address at that time?
We have, the notice is to his street address, Your Honor. And let me make sure I do have his. No, Your Honor, he did not.
And that's probably, yes, because I see that he received notice of the hearing and he also received notice of the hearing while on the record. However, he didn't receive the Zoom information.
No, and we did, or his ex-wife did provide him the Zoom information, but not till this morning, where he said he had gotten no notice. The Attorney General's office, I don't see them present either.
No, they were here earlier, but they didn't say that they had any other case. But so the Zoom information, he did receive it this morning.
From us, Your Honor, yes.
Okay, well, he had notice of the hearing, and notice is what we're required to give him. The link, he had it in plenty of time before 11 a.m. So just, if you don't mind, just let him know that he needs to get on with that information. If not, we're going to proceed without him.
Yes, Your Honor, and then if we could be recalled.
Yes, I will.
Thank you, Your Honor.
Okay, Attorney Roby Flores.
Hello, Judge.
Good morning, sir.
Morning. Judge, we're set for a final hearing today. I spoke to opposing counsel. He is saying he didn't get 45 days notice of a final hearing. The child custody evaluation has been done. We had entered into a temporary order back with the court on June 28th of 2021 that provided basically for the shared custody. They even split up the summer, and we agreed to the evaluation. The evaluation came back basically ordering or recommending what they had been doing all along during their relationship and marriage. In light of his request that they want to reset it because he didn't have 45 days notice, I'm going to ask the court, these parties have been residing together. They did it by agreement because we thought this child custody evaluation would resolve the issue. We didn't go to mediation relying on the evaluation. The evaluation basically is recommending an AD plan, shared custody, no support. My client is willing to, they both share an apartment. They're both on the apartment leases up in December. My client will agree to move out within a week, or she can move out within a week because the rent is kind of high. But as you can imagine, it's no longer comfortable sharing this child on an equal basis, both residing in the same place. I've e-filed the child custody evaluation as an exhibit. I'd asked the court to take judicial notice of the temporary order where they agreed to the shared custody and the splitting of the summer, basically. And so if they don't want to proceed on the final, however they want to do it, if they want to relocate out of the apartment, that's fine. If they want my client to relocate, that's fine. And I have the child custody evaluator online. I just text her. Gilda Bowen is the one that made the recommendation. And we're just looking for some guidance from the court because ultimately I think the only issue is going to who establishes primary based on the child custody evaluator.
Okay, Mr. Arredondo, any response?
Your Honor, that is correct. Judge. I have been in communication with Mr. Roby Flores. Judge, it is my understanding, Your Honor, that there was a previous divorce filed between my client and Mr. Michael Castillo, and they were not following what the child custody evaluator had written, Judge. Although there was a temp order, Judge, although it was never signed, they did abide by that, Your Honor. Obviously, Judge, we're not in agreement, Your Honor, to continue to proceed on the final hearing today, Judge. We're not in agreement. It's pretty much going to be disputed, Judge, if we're going to go forward with temp orders. So we're respectfully requesting, Judge, that this honorable court allow us to continue to mediation, Judge, before we can proceed on any temp orders or final hearings.
You know, Judge,
Okay,
you know,
well, what I was gonna say was, I have here that I signed a temporary order on July 19th, 2021. Do you, and it has your signature on it as well, Mr. Abelondo. Do you recall that order?
I do, Your Honor, but that was only for the, regarding the trip.
Summer.
That was in the summer.
Okay,
no, that's not what it says, Judge. It says the party shall remain in the residence and shall not change, and the party shall share possession of the child. And we were very specific because each party wanted to take the child out for a week. The evaluation was done, we thought, to avoid some costs in mediation and look to the child custody evaluator to make a recommendation. If the court will take judicial notice of the child custody evaluator, she's recommending an A-B plan. Of course, the primary residence is left up to the court. I'm asking the court on its own motion to enter a temporary order. You don't have to assign a primary residence to anybody. Agree to the A-B plan or the 1 week, or however they want to do it. I think the child custody evaluator did it because it provided continuous contact for both parties. My client's willing to move out in a week, but he doesn't want to move out unless he knows we're going to have an order in place that gives him the shared custody that they agreed to by agreement back on July 19th, or actually June 28th, signed by the court on July 19th. There's no real property at issue here. You've got a child custody evaluator who they agreed to do the child custody evaluation. Now they don't like that. You know, they don't like the temporary order, if I'm hearing Mr. Arredondo right. They don't like the child custody evaluator recommendation, and they want these parties to continue residing in the same apartment. You know, they can pick. She can move out if she doesn't want to pay that rent. It's a hefty rent, and he'll stay, or he'll move out and he'll have to go get an apartment, and he can do that within a week. But it's not healthy, Judge, that these two parties remain in the same apartment. They've agreed to the shared custody previously pursuant to that temporary order. You don't have to, we're not asking you to make a recommendation on the primary. In fact, the child custody evaluator said, obviously that's in the purview of the court, but she was very clear in her report that the AB plan is what she recommends, that neither party is required to pay child support. They're both school teachers. They both make basically the same amount of money. There's the issue of daycare. My client will make whatever arrangements during his period of possession. She can continue to leave it with her mom during her period of possession if that's what she chooses to do. But, you know, we're looking for some relief from the court based on the previous agreements and based on the child custody evaluator's recommendation.
okay, so Mr. Arredondo, do I understand you correctly? You're disagreeing with the child custody evaluation?
That's correct, Your Honor. Judge, and if Mr. Roby Flores is asking for you to take judicial notice of the child custody evaluation, Judge, that report also states that Mr. Castillo is comfortably living together with my client, Judge. Further, he's been living there, Judge. These issues have never been raised before. This is the first time that we're hearing of them, Your Honor. And I don't see where the problem, my client states no problem. In fact, Mr. Michael Castillo is always inviting my client out to eat, Judge. And we're not saying that we're not going to proceed, Judge, or we're not going to agree to the evaluation report, Your Honor. We're just asking this honorable court to order our clients to go into mediation before we sign any final orders.
Okay, so I'm looking at your temporary order. Before I say what I'm gonna say next, is that the only temporary order that you're relying on? The one that I signed on the 19th?
That's correct, Judge.
Okay. So the way that I see the temporary orders regarding the child, that it just says that the status quo of the parties shall remain, that the residence of the child shall remain at that apartment, and it shall not be changed until further order of the court. However, as to visitation, it only addresses that time period, which seems is from July 12th through July 27th. That's it. It doesn't say alternating weeks will continue.
No, it doesn't, Judge, but it does say the party shall share possession of the child. And I have Ms. Gilda Bowen online, Judge, if you have any questions of her.
No,
she-
I'm not ready to hear from her, but so the party shall share possession of the child, yes, but that's still ambiguous. Now, because share possession of the child could mean anything. It could mean 50%, it could mean, a standard, even standard is sharing possession of a child. Now, how old is this child?
2 years and 2 months, Judge. I guess the question is, Judge, if we can't proceed to a final because he's raising a technical claim of 45 days, can I proceed on temporary orders? And I'm ready to proceed with.
Your Honor, Arredondo's in court right now.
I'm sorry? What, okay. And what about, okay, so and Mr. Arredondo, what are you relying on for 45 days notice?
Judge, I don't have the exact family code section right off my head, Judge, but I know that under the Texas Family Code, 45 days, Judge, is required, and Mr. Flores is in agreement with that, Judge. I know we received notice of the final hearing, Judge, but we did receive it on August 30th, Judge, so that, I guess we're at the 16 days, Your Honor.
I'm not going to mislead the court, Your Honor. The Rule 245, and it's not the family code, it's Texas Rules of Civil Procedure, that the first notice of hearing, they're entitled to 45 days under TRCP 245. But the court also has broad discretion to enter temporary orders. And so I have to acknowledge the fact that he is entitled to 45 days. And on a second notice, I mean, could you shorten the time? You can. You could reset for a final in 2 weeks or 3 weeks. You could.
Okay, I was just, now I understand how you're relying on that. It's because normally on final hearings for family, you're relying on it as if it were a trial setting then. Okay. And then mediation, you all haven't gone to mediation yet.
That's correct, Judge, no mediation yet.
Because I think now, if Mr. Arredondo will also acknowledge, we had agreed to rely on this child custody evaluation because we didn't want to go through the cost of mediation. Those are also representations we made to another, but now they don't like the result, and that's the problem.
Okay, so I think that's where the miscommunication, well, not so much the miscommunication, but if in fact you all had agreed that you were going to rely on the child custody evaluation and instead of going to mediation, and whether you changed your mind or didn't change your mind, I'm not going to entertain a contested temporary orders hearing until you've gone to mediation. So I'm going to give you an opportunity to mediate that, and I'm going to refer you all to mediation. And I know your schedules are both pretty packed. So if you want this mediation to occur, you need to get it done within, my standard is within the next 30 days. If you want a shorter time period, let me know. I can shorten it to the next 14 days, but I need for y'all to be realistic with your calendars. So do y'all want to mediate this within 14 days or within 30 days?
Your Honor, and I speak on my own, Judge. I'm ready to mediate, Judge, at any time. I would like to confer with my client, Judge, beforehand, before deciding whether a 14 or 30 day would be more appropriate.
Well, it's not up to her. It's whether your calendars, I know both of you all have very packed calendars.
If it could be done within the next 30 days, Judge, we'll go ahead and get it done, Your Honor.
September 30th is a good day. If he could look at his calendar, we can mediate on September 30th.
Well, that depends on the mediator as well, so.
I'm sure we're going to be able to find a mediator that somebody will certainly be able to entertain us by that date. And I don't really care who the mediator is, Judge. I think I know what their position is. I think it's going to fall on deaf ears, but be that as it may.
So then what we'll do is I'm gonna send out an order of referral of mediation to mediate by October 1st. Since there seems to be an urgency on both sides. For the future, Ms. Robles, I'm assuming the child that's on your laps is the child in question. Don't bring her to hearings anymore, okay? Don't answer. I'm just letting you know. Mr. Arredondo, make sure that that child is never to be present at any of the hearings. Although she's small, I don't know what she's capable of understanding. I know that my 2-year-old at the time would be able to know that there's at least conflict. So,
Will do, Your Honor. I'll go ahead and notify my client.
okay, I'm gonna go ahead and send out that order of referral mediation, and it should be sent out to you by the end of the day.
Judge, just one more request. If the mediator that you select isn't available, can we have the deference to try to find another mediator to meet that deadline?
Yes.
All right. Thank you.
And
Your Honor.
then you're to check in with the court and let me know whether or not you all settled, so that if not, I can put you back on the docket for a contested temporary orders hearing.
What Judge, at that point, we could set it for final because it's more than right. Can you just give us a final setting now?
No, I'm not prepared to give you a final setting for a contested hearing. What we'll do is, it sounds like if you're going to be doing a final hearing and it's as contested as it seems like it's going, then you're probably gonna need some time to get any subpoenas out that you may need. So if that's gonna be the case, then we may have to do a DCC so that we make sure that both of you all will have that time and date cleared on your calendar. Because from what I'm hearing, it's sounding at least a 2 to 3 hour hearing.
What I was hoping you could just give us a final setting in November and that way we already know it's coming. We don't have to take up more court's time on a DCC.
No, we'll go ahead and do it like this. Just call us and let us know if you settled or not, and then I'll guide you on the next step.
Will do, Your Honor. That's all I have
Okay,
for today,
and
Judge.
also,
May I be excused?
yes. Now, Mr. Flores, I was gonna ask you, this afternoon, you're set on my afternoon docket. Is that case moving forward?
Let me see. I've got to talk to Lucy Williamson, yes, because we do have an issue. Let me see. Give me a second, Your Honor. Yes, Your Honor.
Okay, so then you will be moving forward on that hearing this afternoon?
Yeah, and it should be pretty quick.
Okay.
All right.
All right, then we'll see you this afternoon, sir.
Thank you, Your Honor.
Okay, you may be excused.
Appreciate it, Your Honor. Have a good day.
Thank you, Your Honor. Have a great day.
Likewise, Attorney Audra Palacios Cruz.
Good morning, Judge. Number 34 in your docket.
Okay, F 3397-21-9 in the matter of the marriage of Kimberly Escobedo and Cosme Escobedo.
Your Honor, Audra Palacios Cruz, on behalf of the respondent Cosme Escobedo. I do not see opposing counsel on the Zoom hearing, which is why I didn't make an announcement. My understanding is that the parties are working towards an agreement. They have sent us a draft of temporary orders that my client has reviewed. However, there are some changes that need to be made. But it seems that the parties are working out an agreement as to temporary orders.
Okay, and then what about the pending motion for hair follicle? Are we holding off on that?
Yes, Your Honor, we're holding off. That is our motion, our request, so we will be holding off on that pending the temporary orders.
Okay, then how much time do you need so that you can review and work towards the agreement?
Judge, we'd be asking for about 2 weeks. However, my availability right now is tentative. Yeah. So if the court would like to give us 2 weeks for submission of temporary orders, and if they are submitted, if the court would entertain just continuing on with the case without the hearing.
Okay, so if it's for temporary orders and all the parties sign off on it, plus the attorneys, I'll accept it. It's only for final when it involves kids that I won't accept it without approval, but for temporary orders, I will.
Thank you,
So
Your Honor.
I'll give you some time on that. What I'll do is, given your situation at this time, I'm gonna go ahead and just set a tickler for October the 8th.
Thank you,
Just
Judge.
to see if that's been submitted, and if not, we'll touch base with your office as to whether you'll need a setting after all.
Yes, Your Honor, we are actively working on that, so hopefully we'll get that to the court sooner rather than later.
Okay, so I'll set the tickler for October 8th for submission of agreed temporary orders.
Thank you, Judge. Nothing
Okay.
further, if I may be excused.
You certainly may. Okay, Ms. Fuentes Aguilar, were you able to speak to Mr. Ukegbu?
Yes, Your Honor, we do not have an agreement. Judge, there is no answer on file. This is Mr. Okegbu's first appearance, and my client is asking to be able to proceed.
Okay, Mr.
So-
Ukegbu, will you be hiring an attorney?
Yeah, I'm just requesting that I could be able to seek some legal counsel. I reached out to, I'm sorry that Ms. Aguilar's office wasn't able to receive any type of communication. I was trying to be able to get in contact so that we could be able to get this taken care of. But yeah, I also reached out to the legal aid here in Hidalgo County. They said that they are not providing any help as of right now with family law court because there's so many cases. I reached out to them on their Tuesday and Thursday times, but I'm hoping I could be able to find some type of legal representation, hopefully by November and December, and get this taken care of. Is that possible? We could be able to do that?
Okay, so I'm gonna give you an opportunity to hire counsel. I'll see you back here on November the 1st, but I'm setting you at 11 a.m. Because if you do not have an attorney, then you need to be prepared to move forward pro se.
Okay. Sounds good.
Judge, because we, like I said, we have not had an answer, and I had not talked to Mr. Okegbu. There was an incident yesterday where he went to the school, and my client believes to try to withdraw them. So we would ask that there be some kind of temporary orders giving him just the standard visitation.
Okay, Mr. Ukegbu, your children are not to be withdrawn from school, okay?
Correct.
They
I
need
did
to-
not do that.
Okay.
The mother of her children did that. I did not have any intentions to withdraw them from school. If you ask Iris and if you ask Idea School and Elsa what happened, they will be able to confirm with you that did not request to be able to pull them out of school. They were not even in school at the time when I arrived at school.
Okay, how old are the children, Ms. Fuentes Aguilar?
8 and 6.
Okay,
Yeah, Liam's birthday is coming up here on the 21st.
okay. Well, since, and Mr. Ukegbu, are you objecting to having standard possession of your children?
When it comes to, I do not understand what standard possession is.
Okay. Well,
Judge, he doesn't, I know, even though Mr. Okegbu says he resides here, my understanding is that he's primarily in Dallas. So we would ask for some kind of notice, at least 7 days, that he intends to exercise his visitation. And I did explain to him that it would be a weekend, like Friday to Sunday. But I don't know if he'll accept that.
okay, so my priority is the children. And I do know that you're saying that you have one of your children's birthdays coming up. So you're going to want to ensure that you see your child at least for a couple of hours on that day. But I can understand where Miss Ariasola will not want to release the child unless she has something stating that she's going to get the children back. So the best that I can do in this certain situation, hold on.
I'm sorry. Oh, okay.
The best that I can do in this certain situation is go ahead and have Ms. Fuentes Aguilar e-file a proposed temporary order for my review. And of course, you can send it to Mr. Ukegbu. And just give him, Mr. Ukegbu, you're to review it If you agree with it, you can sign it. If you don't, then Ms. Fuentes Aguilar is to still e-file it for me to look at.
So,
Because something needs to be done with respect to the children so that you get to see your kids. And Ms. Ariasola also has the comfort that she'll be having the kids return whenever you do see them.
Judge, I took them on a 5-week road trip just a month ago. I have no intentions of keeping them away from their mom. We went to the Grand Canyon, we went to Legoland, we went to Seattle, Washington, we went to New Mexico, we went to Colorado. We went to at least 5 different states over 5 months in a 5-week time period. And no way did I try to be able to prevent or take our children away from their mom.
Okay,
So
hold on.
I'm not sure where.
Mr.
where
Kegbu,
there's
hold on. I understand that. And that's great because you are entitled to, if you're living in Dallas, you're entitled to 42 days in the summer anyway. So that's wonderful that you, hold on.
I don't live in Dallas.
Okay. So either way, you're entitled to summer possession of your children, and it's wonderful that you were able to create all those memories. But in family law cases, the way you feel today doesn't necessarily mean that you will feel like that tomorrow. Or the way that you felt a few weeks ago doesn't mean that that's how you're going to feel today. It's just, unfortunately, that's just life in these cases. And I understand what you're saying. And, but it's my job to make sure that there's something in place so that it is in the children's best interest. So the sooner that you can get counsel, the sooner that you're able to start receiving some legal advice as to what your rights are, okay? I can't do that for you. I can't give you that advice. I can't guide you. So the best that I can do so that you can see your children and vice versa, I'm going to entertain a proposed order of temporary orders, okay? So review them when they're sent to you. If you agree with them, sign off on it. If you don't agree with them, I'm still going to review it. And if I think that it's fair, then I'll go ahead and sign them into orders, okay?
Is this a document that's going to be like in the best interest of the children, or like the fear that Iris felt?
No, sir.
Just like you mentioned, like you could feel one thing on another day and you could feel another thing on another day. Is this why that document is getting filed?
No, this is for the best interest of the children. And it's so that we can make sure that something is in place. I hope you all can continue to co-parent. I hope you all can continue to get along. But in the event that you don't, something needs to be put in place. So I'll go ahead and review it. So Ms. Fuentes Aguilar, I guess just go ahead and get an email address from him. And I also need an email address for you in case you continue to represent yourself pro se. So can I get that, sir?
Yeah, do I put it in the chat?
No, you say it on the record.
Oh, I say it on the record. So it's going to be my last name, UKEGBU2XI@gmail.com.
Okay. That way, if you continue to represent yourself, the Zoom link will be sent to you for the next hearing. So
Judge, can you repeat the email one more time? I'm sorry.
He said it was UKEGBU2XI@gmail.com.
Okay, I'm sending him an email right now, Mr. Kegbu, if you could just confirm you receive it, please. And I don't mean right now, Judge, I just mean.
Okay, so, all right, then what I'm gonna do is I'm gonna go ahead and set you for, like I said, on November the 1st at 11 a.m. And that'll be for the final hearing.
All right, thank you, Judge.
And then between now and then, I would just, if you get counsel, just make sure you get that person pretty quickly here, okay?
All right, thank you.
Okay, anything else?
May I be excused as well?
You certainly may. Okay, so Miss Attorney Sophia Ramon, the hearing that, due for the sake of time, the hearing that you all were having at 11, we pushed it to 1:30.
Oh, okay. Thank you,
Okay,
Judge.
so we'll have a new link sent out to you.
Okie dokie.
Okay, thank you.
Thank you.
Okay, so Attorney Eric Barrera.
Yes, I'm here, Your Honor.
Okay, and what case are you here on?
I'm here also on that
McCoy?
Young McCoy's.
Okay, so
Okay.
it'll be at 1:30.
Understood, Your Honor. Thank you.
Okay, thank you so much. Okay, Attorney Sergio Sanchez?
Judge, good morning.
Good morning. What case, sir?
Your Honor, I've got an occupational license. I believe it's unopposed.
Okay. That is CL 21-2912-I. And is Mr. Solis present?
Yes, ma'am.
Elvis? Okay,
Yes, ma'am.
all right. And Mr. Wind, is this opposed or unopposed?
This will be unopposed, Judge.
Okay, Mr. Sanchez, you want to prove it up? Mr. Solis, I need you to raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, go on, Mr. Sanchez.
Thank you. Sir, could you please state your name for the court?
Elvis Solis.
And Mr. Solis, you're asking the judge to grant you an occupational driver's license?
Yes, sir.
And what was the reason that your license was suspended?
DWI.
Okay. Was there an accident in that case?
Yes, sir.
Okay. Is this your first DWI?
Yes, sir.
And do you have any other alcohol-related offenses?
No, sir.
Okay. And you understand that if the court is going to grant you this temporary occupational driver's license, that a mobile alcohol device is required. You understand that?
Yes, sir.
And you're asking that there be no geographical restriction on this driver's license.
No, es mujer en el iPhone. Sí.
That means, sir, that you could drive anywhere in the state.
Yes, sir.
And you're asking that you're able to drive 24 hours. Is that correct?
Repeat that again. You cut out.
You're asking that there be no time limit, that you be able to drive 24 hours a day if you.
Yes, sir.
Okay. Your Honor, that's all we have. This is from a standard suspension from a DWI arrest. And we are asking that the mobile device, no geographical restriction and no time limitation be in order.
Okay, Mr. Wind?
Judge, if I may, the statute required not a mobile device, required the interlock device, Judge.
Oh, okay, understood, Your Honor.
Okay, if he's gonna want no geographical restriction, no time restriction, it does have to be an interlock device.
Yes, ma'am, Your Honor. We'll include that in your order.
Okay, Mr. Wind, anything else?
Nothing else, Judge.
Okay, so the court will approve the occupational driver's license provided that Mr. Solis does get an interlock device. That interlock device does need to be placed on his vehicle within 48 hours of the occupational license being signed, because they won't put it on, I think, unless he has that order. So when do you think you'll be getting that into the court's queue, Mr. Sanchez?
Judge, that's going to be filed within the next 5 minutes. We just need to make that one change to include the Guardian interlock device rather than a mobile device.
Okay, then I'll go ahead and ask my staff to look for it and have it sent to my queue.
Yes, ma'am, Your Honor.
Okay, anything else?
That's all I have, Your Honor.
Okay, then you may be excused.
Thank you very much.
Okay, thank you. Okay, Ms. Williamson, I don't think he's going to be getting on.
Your Honor, he might be the Galaxy Note.
Oh, okay.
Ma'am, is this court for child support by any chance?
It depends on your case, but I'm not a child support court. What's your name?
Sasha Cantu.
Who gave you the link?
Some other child support officer, but I don't know if it's the right one because I don't see the other parent on there.
Yeah, I don't have you on my list.
Okay, let me get out and go back in.
Okay. All right. Okay, what number was this again, Ms. Williamson?
Your Honor, I don't know, and I apologize, I don't know what number.
Oh, I have it.
Yeah, sorry.
It's okay, sorry. Okay, that's F1362-12-9. Okay, so Mr. Martinez, are you present?
Yes, ma'am, I am.
Okay, so sir, are you gonna continue representing yourself?
Yes, ma'am.
Okay, so Ms. Williamson is prepared to move forward on this final hearing. Are you
Yes,
prepared to move forward?
Yes, I'm sorry that I just found out about court today a little while ago, just because Elizabeth sent me a message that I had court at 11:10 and I didn't know. I'm sorry.
No, we sent you a notice to the address that we have on file, sir.
Remember, I had the same problem last time. I had the
Yes.
exactly same problem that they tell me that they send me notice to my house, and they have my email, and I check my emails every day, and I don't know for what reason I don't get them. I don't know why.
And also I gave you this date on the record, the last time that you were here.
Okay, the last time you gave us September 1st, which I was ready for court, and it got canceled by the court. It got canceled, and I called Miss Williamson's office. I know that it's not her obligation to give me the date, but her staff was nice enough to tell me that they didn't have a date yet. The same day that September 1st, I called the office, and they told me politely that they didn't have a date set yet. So I didn't know it was today, as you can see. I'm sorry. If not, I would have been here early.
Okay, so the order was sent, the order setting hearing. So are you at 203 Hector Drive in Alamo, Texas?
Yes, ma'am.
Okay.
And
I'm not sure.
last time, I don't know why it's been happening, and this been going on for years.
Okay.
I don't know why, but it's been happening for maybe 2 or 3 years. The same thing.
Okay, so then now you're on and we can proceed. So Ms. Williamson, are you going to be putting on any testimony?
Your Honor, I know I spoke to him right now and he's willing to make some payments, but what I'm asking that we come back to see if he has complied. There's 2 issues here, Your Honor. There's a failure that he failed to comply with the division of property. He was to pay $10,000 as the equity for Ms. Carrera's part of the home, and that was due in 2013. He did not pay any part of that until we started this court, and he paid $5,000. So there's $5,000 due of that, and that was paid in 2020. Then our second action is that he is behind in child support. As of today, it's combined child support and medical support in the amount of $9,743.38. Your Honor, what I am asking at this time, that he pay he agreed $1,850 a month for 3 months towards the division of the marital estate that was ordered back in 2013, and that he continue his child support as ordered, plus that a payment of $200 be made towards the arrears, and that we return to court sometime in January to see if he's complied. If not, I am going to be asking the court for jail time, Your Honor.
Okay, so Mr. Martinez, do you understand what Ms. Williamson has put on the record?
Yes, I do, ma'am.
Okay. So, and are you able to comply with paying the $18.50 for 3 months for the remainder of the property balance? And also pay your child support as ordered and an additional $200 in child support arrears.
Yes, ma'am. Just for the record for the court, I did owe about 7,000, but I that's probably from about a year and a half or 2 years ago that I still owe that because I've been paying. I think I missed 2 or 3 payments. She told me this year, but I've been like for more than a year. I've been trying to pay exactly what I owe. But I know I owe that the what she's saying that I do owe, but it's not that I owe 9,000 that I haven't paid at all. But just for a record, but I do what she's saying, I'll do it.
Okay, so she's gonna put that in a form of an order, okay? So when she does that, it is gonna require your signature. So once again, what email address do you receive documents at?
Sergio 7 days, SERGIO 7 days, SEVENDAYS @yahoo.com.
Okay, so Sergio 7 days spelled out, SEVENDAYS @yahoo.com.
Yes, ma'am.
Okay.
And Your Honor, would it be possible to get a reset date then maybe in February?
Yes. I have February the 9th.
That's fine with us, Your Honor.
That's
And
fine with me.
Okay, and that'll be, I'm gonna keep it at 11 a.m. in case you need a contested hearing.
Yes, Your Honor.
Okay.
And then, Your Honor, I just want him to understand that the payments of the $18.50 are due October, November, and December 1st, and they're to be paid directly to my office by way of money order or cash, which he will be given a receipt for, and then he's to continue paying his child support as per the court order. It needs to go through the disbursement unit.
Can you send me can you send me an email with your address and everything so I can send it to you?
Absolutely, Your Honor. When I send him the order, that will all be in there.
Okay, so then I'll go ahead and look for that. As soon as you get it, then I do need for you to sign off on it, Mr. Martinez, and then also yourself, Miss Williamson, and Miss Martinez as well, okay?
Yes, and Ms. Cabrera now, Your Honor, and she is present here in my office.
Okay, all right. Okay, then I'll go ahead and give you an opportunity to get that done. And I'm gonna go ahead and set a tickler for October the 22nd, just to make sure that it's been submitted.
Yes, Your Honor. I will submit it.
Okay.
Thank you, Your Honor. I have nothing further before this honorable court.
Hold on. And since it's really not, I don't know if you want to entitle it temporary orders, it's not really temporary orders, or you can say order in the interim, or I don't know how you want to title it, but.
I'll do order in interim, Your Honor.
Okay. And Ms. Williamson, not on this case, but I did ask Mr. Flores if you all were going to be having that hearing this afternoon.
Yes, Your Honor.
Okay, so I just wanted to make sure that you also were on the same page, that you all were still going to show up.
On Aurelio Quesada, yes, Your Honor, and I'll get a hold of opposing counsel right now just to verify that he's going to be available. I am.
Okay, and he did mention that it would be quick, but nothing we do is quick, so.
Yes, yeah, nothing is quick, Your Honor.
So if you can do that, that'll be great. Okay.
Thank you, Your Honor. Yes, I will.
And just to let you know, Ms. Williamson, I do have a contested hearing at 1:30. So I probably won't get you all started until 2:15 or 2:30.
Okay, Your Honor. I'll talk to opposing counsel to see if we can make it a little bit easier too, if we can come to any agreements.
Okay, and if you do, and you just need a very quick announcement, jump on at 1:30. So
yes, Your Honor.
On with your day, okay?
Yes, Your Honor. Thank you very much.
Okay, thank you.
Bye.
All right, Mr. Martinez, thank you for appearing, and we'll see you soon.
Thank you, ma'am.
Okay, has anybody called on number 5 or number 6?
No, ma'am.
Okay, go ahead and set those on the next drop docket. And number 17,
No, ma'am.
okay, the same. Go ahead and set that for the next drop docket. Okay, the remaining case number 37 has been reset to 1:30 p.m. All right, we are now off the record. Let me stop the live.